Let down all the windows. Turn the car off. Put your hands out the window. Get out of the car. Go to the front of my car. You're not free to go. You're driving reckless, you're about to cause accidents. Face the car. Put your hands behind your back. Any reason why you're driving reckless? You have a valid driver license. Okay. Have a seat. You been to jail before?
No.
Okay. Where are you going today, okay?
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Today's case comes to us from a YouTube channel called Mr. Hot Water, and it depicts a DUI arrest that occurred in Indian River County, Florida in March of 2023. The source video is 20 minutes long, so I've edited out all but the portions relevant to our discussion, but I do encourage you to go watch the whole thing for yourselves and give them credit for sharing it. I decided to focus on this case today because, quite frankly, it illustrates one of the most poorly handled traffic stops / DUI investigations I've ever seen. In fact, I would go so far as to say that this encounter is a living, breathing motion to suppress. Let me give you some context. The video begins when an Indian River County Sheriff's deputy initiates a traffic stop on a vehicle driven by a lady named Ashley Fritz. The stop starts out almost like a felony stop, with the officer demanding that Ashley roll down the windows, turn off the car, and put her hands out the window, and it just escalates from there. Let's watch.
Let down all the windows. Turn the car off. Put your hands out the window. Any reason why you're driving reckless? About to cause an accident.
I'm sorry.
2204, I'm gonna have adult female detained. Get out of the car. Go to the front of my car. You're not free to go. You're driving reckless, you're about to cause accidents. Face the car. Put your hands behind your back. Put your hands behind your back, like this.
So if you go back and look at the timestamp on the footage, you see that within 45 seconds of exiting his vehicle, this deputy has Ashley out of the car in handcuffs and is asking her questions. Now, I wasn't joking when I said that this is a living, breathing motion to suppress. Real quick, put a timestamp down in the comments and see if you can list a couple of the constitutional issues that you see in the first 2 minutes of the video. And then I'll give you an idea of what I see. Now, there's a lot to unpack here, so buckle up.
Why, Yankee, I have another car heading south in Old Dixie, driving in a reckless manner. What's behind this car? Couldn't make out what it was. It was black in color. Bro, and you've been drinking. No wonder you're driving terribly. So right now, you're not free to go. Right now, you're being criminally charged for reckless driving, okay? Do you have anything on you that will poke me, stick me?
No.
Any narcotics in the car?
No.
Okay. You have a valid driver license? Okay. Have a seat. You been to jail before?
No.
Okay. Where are you going today, okay?
So you notice here that he starts asking her incriminating questions as he's putting handcuffs on her. He tells her, "You're not free to leave." That starts at the 20:56:45 timestamp on the body cam ticker. At 20:57:22, some 37 seconds later, he says, "Oh, and you've been drinking." And his voice inflection and the way that he reacts to it lets you know that whatever he smelled caught him off guard. He's made no stated observation about her eyes or a smell emanating from her vehicle at this point. It's obvious that this is his first clue that alcohol is involved. Then, at the 20:57:28 mark, he tells her she's being criminally charged for reckless driving.
You almost caused an accident. Do you know that? And the nose of your car almost hit my car.
I'm sorry.
No, you can't be, because you're driving like a maniac. You've been drinking. I can smell it coming out of your breath. I can see it in your eyes. Your driving pattern's terrible. Who was that in that other car?
I honestly have no idea.
So why are they driving just like you?
I don't know.
Okay, did you know that when you went around this car over here that you're not allowed to do that on this roadway? Okay, did you know that? When you came into the opposite lane of travel, right, while other cars are driving, you know that's reckless, right? Do you understand that? Do you understand how you could have killed someone tonight and hurt somebody, including me? Okay, so you're going to jail tonight, okay? For that. I'm going to read you your rights, and you're going to advise me if you understand or not.
She's under arrest at this point. She's not being detained, she's under arrest. And he continues to lecture and question her prior to issuing a Miranda warning at 20:58:45. So for 2 entire minutes, she's in custody, either detained according to him or officially under arrest. being literally interrogated by a person who pulled her immediately out of the car without so much as advising her of who he was or what department he works for or anything. First and foremost, just as an initial comment, this is what policing by ego gets you as an investigator. We quickly learn from the way he's talking to her and the fact that he almost immediately arrests her that he's mad because he feels justified in being personally offended that she's driving in a way that he finds to be unacceptable. It's almost as if he believes that he owns the roadways and thinks to himself, how dare she come out here on my streets and conduct herself this way? I mean, people can say whatever they want to about law enforcement in America, but that sense of entitlement, that sense of ownership over all of the area that they patrol, and that idea that you somehow owe them a duty to avoid trying to offend their delicate sensitivities really is what's at the heart of the issue with law enforcement in this country today. Now, reckless driving in most states, and specifically in Florida for this case, is a specific intent crime. The courts have ruled that the state has to prove a willful and wanton disregard for the safety of persons or property in the state of Florida in order for a person to be guilty of reckless driving. And there's a case from 2023 that illustrates this. So it's a Florida appeals court case called Kenneth versus State. And the driver in this case is named Kenneth. He was charged with reckless driving when an officer saw him peeling out at a stoplight and passing several cars and whipping back into the lane of travel all over the course of like 10 seconds. When the state tried him, they didn't put on any evidence of his mental state. They didn't try to prove that he had a willful disregard for the safety of others. They just put on his actions. And they basically said that his actions alone satisfied the elements of reckless driving. And the court said, no, that's not the case. The court said in their opinion that the state has to put on evidence to show that the defendant engaged in intentional conduct, demonstrating a conscious disregard of the likelihood of death or serious bodily injury before they can be convicted of reckless driving. And in the absence of the state putting on that proof, the conviction in this case was overturned. So the actions that Ashley's accused of here really don't rise to the level of reckless driving based on what we have right now. And you'll learn here in a little bit that he doesn't really have an opportunity to get anything else because of the way he chose to handle this. So as of right now, he doesn't have reckless driving. You might say to yourself, James, my eyes are glazing over and I'm about to die from boredom. Why do I care about the reckless driving standard in Florida? Well, the answer is you care because the Fourth Amendment to the Constitution says that as a general rule, warrantless arrests and searches and seizures are presumptively unreasonable. And one of the exceptions to the warrant requirement for arresting a person is probable cause to believe that they did certain things. And one of the ways that you can establish probable cause is that you observe them as a police officer commit something in your presence. Well, before you can arrest somebody based on probable cause, the thing that they've done has to be something that you could actually physically take them in custody for. And in the state of Florida, reckless driving is one of those things. But again, knowing that a specific mental state is an essential element of that crime, you have to at least do some investigation to try to establish that mental state. So at best, when he makes the traffic stop, all he has is reasonable articulable suspicion that she's driven in a way that he subjectively feels is reckless. His job is to try to undertake an investigation that raises that reasonable suspicion up to probable cause. And you might think, well, how can he do that? Well, for one, he could start by not treating her like a felon before he ever interacts with her and make sure she's not suffering a medical emergency. That's one thing that could be an idea. I mean, the police motto is to serve and protect, and that does not refer to an officer's ego, by the way. It's to serve and protect the public, not intimidate and interrogate. And so he kind of missed the point on that. Well, the second thing that he might do is that after he establishes that she's not suffering a medical emergency, he could ask a few questions to try to figure out what's going on. Like, are you okay? Or is there some reason why you're driving like that? But he didn't ask her whether she was okay, or he didn't try to establish any sort of investigation to try to uncover some evidence of mental state at all. I mean, had he done that and her response was like, well, I just don't care tonight. I was listening to music and I don't really care. Or me and my boyfriend just got into it and I'm letting off steam. Well, then at least he has something that he can articulate to push past reasonable suspicion land and into probable cause land. He could at least make a good faith claim that he investigated to the best of his ability, but as you can see in the video, he didn't do that. So if you take a look at Florida law, what he actually has probable cause of is an offense called aggressive careless driving. And aggressive careless driving is when you're doing two or more of the following things, either simultaneously or in succession. Things like exceeding the posted speed limit. We didn't accuse her of that. Unsafely or improperly changing lanes. He did accuse her of that. Following a vehicle too closely. He did accuse her of that. Failing to yield the right-of-way. He accused her of that when she weaves back in and almost hits the front of his car. Improperly passing. Violating traffic control and signal devices. He accused her of several of those things, and what he's actually done is he's established that he's got probable cause for aggressive careless driving. Reckless driving is an arrestable offense under Florida law, but guess what aggressive careless driving is not? Right. It is not an offense that justifies physically arresting someone. It's mandated as a citation and a release as a non-criminal traffic infraction. And that's why it matters as to which charge he has reasonable suspicion for and which charge he has probable cause for. So as it stands at this point in the video, he's unlawfully arrested her during the reasonable suspicion stage of his criminal investigation because as of now, all he can establish probable cause for is a non-crime. And because of his egotistical haste to immediately use the intimidation tactic of throwing her in cuffs and telling her she's under arrest, she's now in custody and is entitled to a Miranda warning. Now let's see how badly he butchers the next part.
You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to the attorney and have an attorney present with you while you're being questioned. If you cannot afford a hire attorney, one will be appointed to represent you before any questioning. If you decide to answer any questions now without a lawyer present, you still have the right to stop answering at any time and speak with a lawyer. Do you understand your rights? Okay, so why are you driving the way you're driving?
I was honestly just listening to music.
Okay, listen. So you listening to music justifies your poor driving, where you almost caused 2 accidents. That's what you're telling me? So you're telling me you listening to music in your vehicle is the reason why you came close to hitting my car, right? And you went into the opposite lane of travel. Is that what you're telling me? So you're telling me that for you to enjoy your music and not pay attention to the roadway, that's what you're doing? So what are you trying to tell me?
I think I'm just going to remain silent.
Okay, so that's cool. Another thing is, you don't have to, I'm going to ask you some additional questions, not incriminating. I believe you've been drinking tonight, right? You have watery texture eyes. Your eyes are red in color.
Worked all day.
I'm past that. I smell alcohol come off your breath. Okay? Then I got up to your car, I can smell it come out of the car as well. Okay? Bro, and you've been drinking. No wonder you're driving terribly. Is that where you wear to work? Okay. Have you had anything to drink tonight?
No.
You haven't had anything to drink? Okay.
I went to
Based on the totality of circumstances and your reckless driving and your driving patterns and your behavior, are you willing to submit to field sobriety exercises?
No, sir.
Huh?
No, sir.
No, sir. Okay. So I'm going to advise you of something that's called Taylor warnings. Okay? I'm going to sum that up for you. Taylor warnings is me advising you that if you're not going to participate in field sobriety exercise, which you can or don't, right? You don't have to or you can, right? That's your right. But if you do not participate, I got to make a decision based off what I have, the way you're driving and your decision you're making. Do you understand that so far? Are you going to participate or you're not? Okay, so you're going to be placed under arrest for a DUI and you're going to be placed under arrest for reckless driving as well, okay?
Yes, sir.
Anything in the vehicle you need? Huh?
No.
There's nothing there you need. Okay. Couple questions, right? For me to go in your car, turn your car up and let your windows off, you gotta give me permission to go in your car. If not, your car's gonna remain on the side of the road the way it is. So do you give me permission to go into your car?
What do you want?
Okay, once again, if you don't allow us to go in the car's gonna remain on the side of the road the way it is with the windows up. Okay. You want to leave it like that? Is any narcotics in the car? None whatsoever. Let's talk for a second. Go on mute, administrative conversation. All right. Step out of the car for me. Okay. Face my car for a second. Take your hand off your butt. Okay, I'm going to take you out of cuffs. And we're going to go over one more thing. Okay, you're still not free to go, okay, just because you're out of cuffs. Okay, face me.
Yes,
You invoked your rights, right? Which you're allowed to do. All right. Do you understand your rights? I just read you.
Yes.
Okay. Now you're out of cuffs. Okay. I'm not gonna ask you any self-incriminating questions. Once again, do you want to participate in field sobriety exercises? If you want to remain to keep the same answer, that's on you. Just give me another opportunity.
So by law, you're required to submit to the field sobriety exercises. That's on the back of your driver's license. But you're allowed to refuse them if you would like. But you have to know, you're going to know that he explains to you the adverse consequences of refusing. take the field sobriety exercises. Do you understand that?
I do understand.
Okay. So are you going to take the field sobriety exercises?
No, thank you.
No, thank you. Okay. So just letting you know, based on everything he has, he can use your no decision for evidence for his case. Do you understand that? You still wanting to refuse to take the field sobriety exercises?
Yes, sir.
Okay.
All right, I'm gonna put you back in handcuffs.
So if I were to do it, I would.
We're past it. We gave you a chance.
We already gave you.
Actually, you didn't have 4
We
chances.
just had to. We want to make sure you feel like you're
I didn't. No.
you're not free to go because you got reckless driving, but we have to make sure that you understand your rights. But you have to understand that a driver's license is a privilege in the state of Florida, not a right. Okay, so it can be taken away. On the back of your license, it says you must consent to any field sobriety exercises or tests that law enforcement asks, which means the field sobriety exercises or the breath test. Okay.
All right, have a seat.
Now, the decision in Miranda says that a person must be advised of their Fifth Amendment rights when they are subject to custodial interrogation. The courts have held that just being stopped on a traffic stop does not trigger a Miranda warning, and you're not in custody for the purposes of Miranda. But because he almost immediately puts her in cuffs and tells her she's not free to leave, she is unquestionably entitled to a Miranda warning prior to questioning in this particular instance. And as a result, any evidence that he gets from her answering any questions or anything that he says to her will be suppressed as improper evidence, assuming that she gets any lawyer with a pulse and not named Frank Abagnale Jr. Little catch me if you can reference for y'all. Now, he does end up giving her a Miranda warning, but just like everything else in this stop, he makes it obvious that he has no idea what it's supposed to mean or what rules it's supposed to set out for him to operate within. And once he gives her the warning, he immediately starts questioning her without even asking her whether she wants to talk. And when his tone is increasingly intimidating, she says, "I think I'm just going to remain silent." In that exact moment, according to the Supreme Court decision in Michigan versus Mosley, his questions of her have to stop. Her invocation of her right to remain silent must be scrupulously honored according to that decision. Well, and you're probably going to wonder, what does it actually mean to scrupulously honor an invocation of silence? Well, there are 5 elements to it, and let's see how he did. Number 1, interrogation has to immediately stop. Well, we already busted that rule because as soon as she said she was invoking her right to remain silent, he said, well, that's cool, and then he started asking her questions. Number 2, no coaxing. The officer didn't try to pressure or otherwise coax them into changing their mind. Well, we busted that one too because he basically just tries to manipulate her into thinking that the next questions he asks are not going to be incriminating, so she don't have to worry about it. Number 3, there's a time lapse. The officers have to wait a significant period of time before they initiate recontact with the person. Well, we definitely messed that one up because there was no time from the invocation of the right to remain silent to the next non-incriminating question. Number 4, no pressure. When they recontacted the person, they didn't attempt to persuade them to talk. Well, we're 0 for 4 here because they went so far as to take her out of handcuffs to make her feel more like she had a chance of leaving if she just cooperated with them. And then number 5, waiver. So the officers didn't make any contact or try to question the person before they waived their Miranda. Well, we do not have a waiver of Miranda here. So we literally missed all 5 of the rules associated with Michigan versus Mosley, which means that literally everything that she says in this traffic stop is subject to suppression and cannot be used as evidence.
I'm not going to ask you any self-incriminating questions. I'm going to advise you of why I'm pulling you over. Okay, so you know. First reason, following too close into the car, you almost hit. Second reason, you almost hit my patrol car. Third reason, you went to the opposite lane of travel while other vehicles were on the roadway. Okay, almost causing accidents. Okay, and I don't need you to give me the answers. The reason why you responded and said you're driving like that is because of listening to music. I think it's a little bit more than that. So that's why you're getting charged with DUI, okay? And you admitted to having 2 drinks, okay? I'm not here to talk to you about the case. I'm going to respect your rights. I'm just letting you know that you need to do better, okay? So once again, with the car, you want to leave your car the way it is. Okay, what I can go into your car for is intoxicants. That means anything that you could have consumed tonight, okay? So that's why I'm asking you if there's anything illegal in the car.
No, sir.
It's none whatsoever. You don't want to lift your windows. You want to leave the car the way it is.
So what we have here is a botched traffic stop that the deputy has basically made impossible to gather any admissible evidence of a DUI or reckless driving because he can't even question her anymore and use anything she says as admissible evidence because of how badly he has mishandled it. He was so aggressive that even if she was drunk, she could see that there was no value in cooperating with this guy. And he'd already told her that she was going to jail before he even knew there was more to the stop that he needed to investigate. And what's worse for him is that as he's laying out his case on camera for her, it becomes obvious that his misunderstanding of Florida law is almost as bad as his constitutional law acumen. So unknowingly, he goes on to articulate the elements of aggressive, careless driving, a non-arrestable offense, other than what he's taken her into custody for. So if you look at the evidence of what he actually has for reckless driving, he doesn't have any evidence of mental state. If you look at the evidence of what he actually has for probable cause for a DUI arrest, all he has is the odor of alcohol coming off her person, which, by the way, wouldn't even have been possible had he not been close to her in the process of unconstitutionally arresting her. So that evidence probably isn't admissible either. And while she's handcuffed, she's not swaying, she's answering questions, her speech is not slurred. We have literally nothing to indicate impairment.
Are you the owner of the car?
Yes.
Okay. Where do you have your physical driver license with you?
Yes.
We need to be able to get in the car. I'm not looking to tear your car into pieces. Okay.
I literally have nothing illegal to do.
Well, listen, I don't want to invade your vehicle, but it's parked on the side of the road. We got certain things we got to do, right? I'm not just going to go in your car illegally, right? I'm going to respect that. Everything I'm doing is on body camera.
In closing, it's hard for me to remember a time when I've seen a more constitutionally inept police officer in my career. It's clear that this guy has no clue what the Constitution allows him to do. He thinks he needs consent, even though he also thinks he has probable cause. He understands that he can go search for intoxicants if he arrests her for DUI. Arizona versus Gant says that he can search the immediate area of the passenger compartment for fruits of the crime, basically, that the person's arrested for. So he couldn't search anything for reckless driving because he's looking for like mental state stuff. And for DUI, he could search for intoxicants, which he seems to understand, but not very well. He doesn't understand that in the process of searching for intoxicants, he can use plain view to develop anything else. He's asking for consent. He also doesn't seem to understand that when you try to coerce somebody into giving you consent by telling them that if you leave their car there, that something bad's going to happen to it, that's not the definition of voluntary consent, that they're still not giving you consent. He probably doesn't realize that it's very likely that his department has a tow policy that would allow him to do a lawful inventory search if he just knew what it was or what the circumstances would be that he'd be allowed to do that. Now, it doesn't matter. I mean, all of this would be suppressed. He could find 7 dead bodies and 5 pounds of fentanyl in this car, and it would literally all be suppressed because of how bad he screwed this up, but that's not the point. The point is that the fact that he doesn't know it is not only pathetic, but it's scary. It's scary that these guys do not have any clue what they're doing. He thinks that if you take the cuffs off somebody, that they're no longer in custody for the purposes of interrogation. He doesn't understand the difference between voluntary consent and coercion. He doesn't understand what it means to have somebody in custody for the purposes of Miranda, and he doesn't understand what Miranda requires of him. In fact, this deputy is so bad at this, it would actually make me feel better if somebody would go check the National Archives to make sure that the Bill of Rights hasn't spontaneously combusted during the recitation of this video. I need a drink. Okay, that's it for this one, kids. Thanks for watching. Please remember to like and subscribe. Thanks for everything you're doing to support the channel. We've gained like 3,000 subscribers in the month of March, so it's been awesome. I put some links to some other videos in the end screen. You guys check those out. Leave me a comment. Let me know what you think. Compare your comments to the timestamps. Let me know what you think about that. Until next time, take care of yourselves. Always film your interactions with the police and keep your evidence to yourself.